This is Seth Rosenberg at the Seattle Litigation Group, here again to read one of the blogs written by one of the attorneys. This one concerns what's called non-economic damages. Non-economic damages, including things like pain, suffering, inconvenience, mental anguish, emotional distress, and injury to reputation and humiliation, are notoriously difficult to assign dollar amounts to. Nevertheless, Washington courts have put the calculation of non-economic damages almost entirely at the discretion of the jury. There need be no evidence which assigns an actual dollar value to the injury. The jury can calculate non-economic damages however it pleases, with few limitations. Courts are allowed to adjust an award of non-economic damages by a jury, but only if the award is, quote-unquote, outside the range of substantial evidence in the record or shocks the court's conscience or appears to have been arrived at as the result of passion or prejudice, or when the amount awarded exceeds rational bounds to the extent that the award could only have been reached by a jury that had forsaken sensible thought and reached its verdict out of outrage, animosity, or spite. That is a very high standard. In practice, an appellate court rarely overturns a jury verdict on this basis. Attempts by legislatures and attorneys to constrain the jury's discretion have met with disapproval. Courts have rejected attempts by attorneys to use jury verdicts from similar cases to show that a damage award was too high. The Washington State Legislature attempted to limit non-economic damages in personal injury cases and death cases using a formula based on the average annual wage and life expectancy of the plaintiff. However, the Washington State Supreme Court struck the statute down as a violation of the Washington State Constitution, which provides the right to a trial by jury on issues of fact. Again, I hope this blog was useful to you, and if you have any questions about it, please feel free to contact us at the Seattle Litigation Group.